Hello everyone and welcome. My name is Munir Nasuli and I want to thank you all for joining me in my presentation on Mueller's Report. This presentation is for IT570 of Marymount University on April 27th, 2019. On today's docket, we will be looking at an overview, points at issue, constraints on the investigation, as well as the overall conclusion, forward looks, the relationship to cybersecurity, and closing out with concluding remarks. But first, the overview. After 2 years of investigation, Special Counsel Robert S. Mueller III published a 448-page report, which was released on April 15th, 2019. The report is about possible crimes, including obstruction of justice, committed by President Trump, and about investigating possible Russian interference with the 2016 presidential election, alongside other charges. After having reviewed the report, Deputy Attorney General Rod Rosenstein and Attorney General William Barr concluded that the president did not commit any crimes investigated by the special counsel. Attorney General Barr released to Congress the redacted form of the 448-page report, stating that the report did not conclude that Trump obstructed justice or had committed any crime. In fact, Mueller himself, in his report, did not assert that Trump did commit any crimes based on his analysis. Despite this fact, many congressional Democrats wish to see the report in a less redacted form. Points at issue. Congress also has been serving subpoenas on several White House officials. For example, the Treasury Secretary, Steve Mnuchin, and former White House counsel Don McGahn, amongst other former White House personnel. White House personnel have been instructed to ignore congressional subpoenas. Critics say that Trump is overstepping his executive power, and they have been characterizing Trump's attitude as overriding the principle of checks and balances from Congress to the executive branch. Now, more legal questions that turn on the friction between the White House and Congress are likely to continue to follow. To the surprise of many officials at the Department of Justice, Democrats and legal experts, Mueller failed to argue that Trump did engage in criminal activity. Mueller's report could reflect his worry of being overruled by the Attorney General and the Department of Justice if his report had taken a more aggressive stance. So perhaps that's why he backed down a little bit. Now, to Attorney General Barr, Mueller had adapted illegitimately the federal law governing obstruction of justice. Barr wrote that such a law should have been applied to the restriction of acts on the order of destruction of documents. Rather, Mueller employed the federal law more broadly, which was troubling in that his interpretation could cover an act as constituting obstruction of justice, even though it may not comport with the more narrow interpretation in which Barr supports. Now we move on to the constraints on the Mueller investigation, and overall conclusions. Now, encryption technology may have hindered the investigation, and the picture becomes clearer in considering that this happened, and it had that encryption technology had hindered or may have hindered the Mueller investigation in a meaningful way. Secondly, Congress did not renew the independent counsel statute, which expired in 1999. As a result, Attorney General Barr became ultimately the final custodian of the report. And Attorney General Barr and Deputy Attorney General Rosenstein argued that there was no obstruction of justice. Now, the Department of Justice's Office of Legal Counsel's opinion states that a sitting president should not be indicted. This legal opinion seemingly played a role in Mueller's decision to not comment on whether Trump committed any crimes, and that he had no authority to do so. Now, some communications between U.S. government officials must be stored and saved under federal law. According to Bob Mueller, his investigation was limited due to the common practice of government officials using encryption tools, chiefly commercially off-the-shelf, commercially available off-the-shelf encryption tools and applications like Signal or WhatsApp. Now, the report was revealed in a redacted manner, and this prompted Congress to call for more information to be released. Now, it would be useful to know more about the nature of any dealings between the Trump campaign and Russian operatives, but much of Mueller's investigation had faced several roadblocks. And given that some of the communications were deleted or relayed using encryption applications, which can also prevent the data from being retained in the long term, Mueller had indeed noted these limits, these actions as limits to his investigation. Looking forward. In a few weeks, Attorney General Barr will testify to Congress to describe in greater detail his take on Bob Mueller's report, analysis, and findings. Now, Mueller did indeed address and affirm Congress's power to check and balance the executive branch upon determining corrupt intent. Pardon that last animation there, was a little quick to jump. Now, talks of impeachment of the president are abound, and the president has expressed strong disapproval for any more investigation. The White House also continues to advise its current and former officials against appearing in front of the House Judiciary Committee, despite receiving congressional subpoenas. The relation to cybersecurity. Device theft is a real threat. And since encryption applications can be open to theft if improperly used, the need to secure and strengthen encryption becomes even more important, especially at times like this. For example, devices that are encrypted end-to-end can indeed protect a user's information and data from being stolen, or at least the content within the end-to-end encryption. However, if they happen to mistakenly click on malicious links, then other unfavorable outcomes might happen. When you're talking about tapping on malicious links, it could be sent from someone who perhaps wanted to gain access to your device, someone like an advanced persistent threat, chiefly this character here, this group of characters trying to hack in. You never know. We also have to consider the transmission of mobile malware, as well as other types of wireless exploits like blue snarfing and blue sniping. Now, blue snarfing is the theft of information from a wireless device through a Bluetooth connection. And it also happens to be a terrible sounding name. This, of the two listed here, this is the more dangerous type of exploit, since the attacker is able to access calendars, contacts, emails, instant messages, and depending on the phone, photos and videos. Furthermore, and again depending on the phone, it is not uncommon to be able to or rather, it is not out of the realm of possibility to force pair the phone and clone the phone, essentially allowing the attacker to view the screen of the phone and what is being on it. Of course, the range of the range that dictates Bluetooth radiuses must be respected. If you go outside that range, you leave the area of the phone, well, then that would feasibly disconnect the forced pair. Next, and lastly here, blue sniping. Now, blue sniping materialized in the early 2000s as a specific form of blue snarfing that was more effective at gaining unauthorized access at distances several times longer than the maximum range of a Class 1 Bluetooth device, which, for your information, is 328 feet, as opposed to your typical Bluetooth range radius of 33 feet, roughly. Now, in a 2005 NPR article, John Herring, the fellow that you see here in this picture, he is a USC alum and co-founder of a wireless security think tank called Flexilis, mounted a directional antenna, a Linux-powered PC, and embedded a Bluetooth module on the body of a Ruger 1022 folding stock semi-automatic rifle, which is what you see in him holding behind him in the picture. This blue sniper was able to target and snarf devices at distances, get this, to over 1 mile. As such, there is a increasing need to invest in decryption technologies. Now, even though encrypted devices can ensure that important information is being detected, we still need to explore new ways of decryption methods. And as more and more communication occurs with the use of electronic devices, lawmakers and federal investigators face more issues in regard to what constitutes as a legal basis for pursuing investigation and in determining what encryption practices could count as obstructing justice under federal record laws. Concluding remarks. These current events highlight the effect that cybersecurity and information gathering has on how the United States handles domestic disputes and new legal questions when cybersecurity and privacy is involved as regards Mueller's investigation. As the topic continues to bloom, the importance of contributing the field of cybersecurity is reinforced. Encryption helps to prevent hacks from foreign and domestic enemies, but as we have seen, it can provide significant roadblocks. In terms of the topic at hand, has staunched much of the Mueller investigation. Forgive the fragment nature of my speaking here. I'm finding it a bit difficult to record a PowerPoint as I've never done this before. But I do appreciate you staying with me. Hopefully none of you are asleep already. Now, questions have arisen about who has the right to access encrypted information in a government investigation. And secondly, what forms of encryption are better suited to avoid such tangled legal questions? Perhaps there should be a special type of a special type of encryption developed for government use only that has the ability for oversight, like a backdoor in the event of a domestic dispute. Perhaps we should look into using a specially designed global system of interconnected device networks using bespoke communication protocols, or a bespoke communication protocol suite, rather. I just kind of came up with a play on TCP/IP, and I called it GCP/IP as a government communication protocols. Perhaps looking to products like, or not products rather, but developments like Web 2.0 as a type of inspiration. Furthermore, additional regulation of what can and can't be used by government officials that is enforceable perhaps is something that should be considered. These are the sources that I used in my presentation, and I want to thank you all for joining me here on this 18 going on 19-minute presentation. I hope none of you all really fell asleep. I hope you all made it this far throughout the show, or presentation rather. And if you have any questions, don't hesitate to ask, whether it's submitting through Canvas or you want to send me a direct message. Enjoy the rest of your day. Thank you very much. Bye-bye.